Hey everyone, so you ever make a deal, you set a date, you have an agreement, and then on the big day, crickets? Yeah, that incredibly frustrating moment is exactly what we're tackling today. We're going to break down what happens, legally speaking, when a promise in a contract is broken right when it matters most. You know, it's a situation that happens all the time. You've got a contract, you've got a deadline, everyone knows what they're supposed to do. But when that day arrives and one side just doesn't deliver, well, that single failure sets off a whole chain reaction of legal consequences. So what happens next? All right, here's our game plan. First, we'll pinpoint the moment of breach. Then, we'll look at the 4 ways promises break. After that, it's all about the aftermath and the remedies, and we'll wrap it all up with some really important court rulings and key takeaways. Okay, first up, the moment of breach. Look, before we can even talk about the fallout, we have to get super clear on the definition. We need to know the exact moment a broken promise officially becomes a legal failure. So, what is an actual breach? Well, it really just boils down to one simple thing: timing. It's that moment the due date arrives, or any time after, and one party just fails to do what they promised, or maybe they even flat out refuse. The key here is that the promise is broken on or after the deadline. And this is a really, really important distinction to make. See, there's a difference between an actual breach and what's called an anticipatory breach. Think of an anticipatory breach like getting a heads up before the due date. Someone basically says, hey, just so you know, I won't do it. But an actual breach, that's what happens on the due date, when you're left there saying, well, you didn't do it. Right. Now, a broken promise isn't just a single event. It can actually happen in a few different ways. And understanding the anatomy of that breach is absolutely key to figuring out what happens next. So there are basically 4 flavors of failure here. First, you've got a complete breach. They do absolutely nothing, a total no-show. Then there's a partial breach. They promised you 100 boxes, but only 60 show up. Next is defective performance. They deliver all 100 boxes, but half the stuff inside is broken. And finally, of course, late performance, which is pretty self-explanatory. They're all breaches, but you can see how the impact is totally different for each one.
But hold on. For a failure to legally count as a breach, it's not enough that someone just messes up. 4 conditions have to be met. The due date has to pass, the failure has to happen, and there can't be a valid legal excuse, like it was literally impossible to do. And finally, and this is so important, the breach has to be material. That means it's a substantial, significant failure. You know, delivering something an hour late might be trivial, but delivering wedding flowers the day after the wedding, now that is a material breach.
So a material breach has officially happened. Now what? This is where we dive into the aftermath. Who owes what to whom when a deal completely falls apart? The path to a breach is usually a very simple, very quick 3-step process. Step 1, the due date arrives. Step 2, the party fails to perform. And step 3, just like that, an actual legal breach has occurred. The second that breach happens, it's like the tables completely turn. The party that broke the promise, they are now liable for damages, and they lose any right to demand anything. But the other party, the one who was wronged, they're suddenly freed from their side of the bargain, and they gain the power to sue for whatever they've lost. And that brings us to the remedies. See, the law isn't just about pointing fingers and saying, you messed up. It's about providing a toolkit for the wronged party to actually make things right. So the contract is broken, the deal is dead. What can the person who was let down actually do? What are their options legally speaking? Well, this table lays out the whole legal toolkit. The default tool, the one that's almost always available, is damages. That's just financial compensation. But when money isn't enough, a court might order specific performance. They can also issue an injunction to stop someone from doing something. And in really serious cases, the injured party can choose rescission, which means just canceling the contract. And that often comes with restitution, which is basically everyone giving back whatever they got. Let's just zoom in on damages for a second, since it's the most common one. The goal here is simple, but it's really powerful. It's to use money to put the injured party back in the exact same financial position they would have been in if the promise had never been broken. It's about making them whole again. Then you've got specific performance. Now, this is where things get really interesting. Instead of just awarding money, a court can actually order the person to do the exact thing they promised. This is pretty rare, though. It's saved for cases where money just can't fix the problem, like a contract for a totally unique piece of art or a very specific plot of land.
Okay, theory is one thing, but let's see how all this stuff plays out in the real world. We're going to look at a landmark court case that established a supercritical rule about how all this works. We're diving into a 1987 Supreme Court case, State of Karnataka versus Sri Rameshwara Rice Mills. This case tackled a really fundamental question that gets to the very heart of these disputes. The whole case really boiled down to one central issue. When two parties disagree, who gets the final say on whether a breach actually happened? Can one party just declare it, and that's the end of it? And the court's answer on this was crystal clear and so important. The ruling was, and I quote, "The determination of a breach must be made by an independent person or court, not by the other party to the contract." That is a huge statement about fairness.
So the big takeaway here is this. You cannot be the judge in your own case. The person who feels wronged, who feels like the promise was broken, doesn't get to be the one who makes the final call. That decision has to be made objectively by a neutral third party, like a court or an arbitrator. All right, let's pull this all together. An actual breach is a failure to perform on or after the due date. It can be complete, partial, defective, or late. When it happens, the innocent party is off the hook and can seek a remedy, usually money. And maybe the biggest lesson of all, you don't get to decide if a breach happened. That call has to be made by an independent party.
And that leaves us with one final thought. After everything we've talked about today, before you sign your next contract, what's the one thing, the one clause that you'll now be looking for to protect yourself from a potential breach? Something to think about. Thanks for tuning in.